Ladies and gentlemen, thank you for taking the time to be with us today, and a very warm welcome to the In-House Counsel Forum program and our first webinar in this year's series. My name is Samir Shah, and I'm a partner in Khaitan's Corporate and Commercial Practice Group. Whether you are our audience in India or around the world, once again, a very warm welcome to you. This program, the In-House Counsel program, was designed by our firm to provide training and education for legal operations, business, management, and substantive legal issues that are relevant to general counsel and their in-house counsel teams, as well as create a discussion forum on contemporary issues that are relevant to the in-house community in India. Consistent with that approach, our subject today is AI risks that GCs must control now. On the next slide is the agenda for today's webinar. In summary, we will have an expert panel discussion, which will be followed by a Q&A session with audience questions. We have already received several questions as a part of our registration process. To all of our live audience, if you have questions, please continue to submit them using the facility provided by the webinar portal. If we cannot, unfortunately, on account of time, cover all questions during the webinar today, we will respond offline by email after the webinar. Also by email, we will be sending summary notes of the discussion and a recording of this webinar to everyone who has registered as a matter of course. With that, allow me to introduce the topic for today, artificial intelligence. It is now significantly already embedded across Indian enterprises, often faster and more deeply than legal and governance frameworks have been able to keep pace. Whether it is procurement, customer engagement, HR, compliance, finance, or decision making, AI is no longer an experiment. It is very operational, very scalable, and increasingly business critical. Therefore, for general counsels, this creates an immediate and personal accountability challenge. Believe you me, these risks are no longer theoretical or by any way future concerns. They present day-to-day legal, regulatory, contractual, reputational, and ethical risks. And each one of these require focused, specific, and active oversight. Whether they are boards, regulators, auditors, or counterparties, they all now expect general counsel to understand where is artificial intelligence being deployed, how are decisions being made, and what are the safeguards that are being put in place. This webinar focuses on which artificial intelligence related risks must general counsels actively control now rather than based on speculative future regulation or technology hype. The webinar addresses regulatory and compliance risks, governance and accountability risks, contractual and vendor risks, and also reputational and ethical risks, which may unfortunately lead to litigation or investigation. So with that, I would like to introduce our panel. And everyone who has registered for this webinar should have already received an email with a summary of their credentials. Suffice to say, they are all experts in this subject matter and qualified to express their views on these issues. On our panel today, we are joined by Ishan Johari, Supratim Chakraborty, and Shumantro Bose. So without further ado, I suggest we start our discussion, and maybe I will start with Ishan. So Ishan, turning to you, from a legal perspective and based on your experience, what do you think is the single largest AI risk that, in your view, Indian general counsels may be underestimating today?
So, thanks, Samir. I think that's a fantastic question to kick off our discussion today. I think from an AI use perspective, I think the biggest risk today is that there's a lot of AI use which is unregulated and in fact is not visible to the management as well. There was an interesting survey that Alvarez and Marcel did last December on AI use across board. And they found out that 80% of India's workforce has adopted AI. Now, the question is that AI is evolving, the use case is also changing, but where is our governance? And that really is the biggest risk. That is an inability to assess how AI is being used and for what purpose it's being used. As general counsels and legal teams, I think the first and the most important thing to do is to assess in terms of real practical risk, where does it lie in terms of your business? Like if, for example, for an organization which is in a high risk sector, like a financial services, fintech, use of AI in decision making could present a larger risk. Similarly, we've seen automotive industries also where AI has been deployed and there have been decision making errors leading to crashes or product recall also. So, getting ahead of these risks by identifying what sector you lie in is very important. The second aspect would be also to assess where AI is being used in the workflow process. To take an example, for example, in HR, using AI to determine which candidate should be selected for or uploading their resumes to build in, say, a questionnaire could present, say, a privacy issue. It could present a bias issue. So, as GCs and legal teams, I think this is the most important thing to focus on right now to understand what AI is being used and for what purpose it's being used. I think a great starting point in that sense would be for leadership to start a mapping of AI inventory and determining against that what is the AI that is being used currently. I think very important to see it as an upcoming unprecedented sort of a situation where regulators, courts, and even public opinion might look at use of AI in a harsh manner where there are issues arising. And it's important for leadership to get ahead of that situation and start putting in processes to mitigate that risk. Back to you, Samir.
Great. I think that's a great starting point. I like how you said that some of the use of AI is very invisible, and management may not even know which all business functions are adopting it and how. So with that, maybe if I try and bring in Shumantro, and Shumantro, to your mind, is this all technology hype, or is there real legal risk assessment that needs to follow the use of AI throughout all business functions?
Thank you, Samir. A very good afternoon to our audience today. I think that's a very important question. Although I'll just reframe, how GC should be looking at this. At the end of the day, AI, just like any technology, is developed by engineers, technologists, people who are on the product side of things. So they define what the capability of a particular tool is going to be. But that does not remain static, right? Once a product is released, law will catch up to define what is permissible, and governance in an organization is going to define where you would want to use it, where you're permitted to use it, and where there are risks to define it, or there are gray areas. I'll give you one example of lawmaking in this arena. Of course, the European Union has come up with the Artificial Intelligence Act. And while that talks about a very generic definition of AI, how regulation in this space tends to work is they're trying to regulate use cases, not necessarily trying to regulate what the capability of AI is. So therefore, you will definitely have AI which can be used in different industries, in different contexts. But the question really lies is how does the regulator look at it? And that is key from an organizational perspective. Let's say if I go back to the AI Act, for instance, that looks at generic use of AI very differently from a use of AI in more sensitive sectors such as healthcare. Naturally, that's a very corollary principle that we also see in privacy legislations, where there are differential obligations when it comes to generic personal data, but there are separate obligations when it comes to more sensitive categories. So looking at it from the perspective that it is a technological issue is not right. You have to see that it's ultimately what is the capability is what technology comes in. But your law and governance is critical because, again, law is governing what is going to be permitted. From the perspective of a general counsel, therefore, use of AI needs to be looked at from a cross-functional perspective. You have to look at what legal is doing. You have to look at what your business teams are trying to do, what they can do, and therefore putting that down on paper in terms of governance principles will be absolutely key. It is, again, complying with the law is also how you are looking at it in terms of mandating compliance in the organization. Who in the organization is going to take liability should something go wrong? Of course, in India, currently, we're still at a very nascent framework when it comes to lawmaking in this arena. And that's what makes looking at this issue from a holistic perspective very, very important, because in case of gray areas or regulator clearly not understanding or liking what is being done, it is the organization who will have to answer for that. So back to you, Samir.
That's very interesting, and I take the point that you mentioned about privacy, and one of the most spoken of legal developments, most awaited, I think, for years together, was the new DPDP Act on data privacy. And who better to talk about it than Shupratim? So, Shupratim, if you try and marry together today's topic and the fact that you now finally have this new law, what are the few messages that you would give to our clients and Indian general counsels in particular about artificial intelligence, compliance, and the DPDP Act, if you were to put everything together?
Right. Thank you. Very good question, Samir. Let me get started. That I think most of the clients that we are assisting today, the assistance is an amalgamated form of compliance in relation to the Digital Personal Data Protection Act, AI, and cyber. Okay, why revisit this three times when you can really fix it now, at least to a large extent, I would say. So for GCs, I would say I think there are 5, 6 things which are super critical when you look at AI and DPDP, right? The first thing I would like to mention here is think of AI use as part of organizations' overall personal data processing under the DPDP Act and not as a separate universe. Because ultimately, remember that the underlying factor is data. And if there is personal data involved, then definitely the DPDP Act would be triggered. Next is, I would say, map the AI use cases that involve personal data at training, fine tuning, and inference stages, and identify the corresponding data fiduciary and data processor roles. What's happening is in the DPDP Act, everything has been written in the context of a data fiduciary or data controller. Okay, that is the entity which is determining the purpose and means as to what is to be done with the data. And that processor who's processing the personal data on your behalf, nothing has been written in that particular entity's context. So you'll have to pass down everything contractually to them. On the reverse side also, if you are a processor, we have often seen controllers, if they are more powerful, then they will pass down more liability, responsibility than is actually the case. Okay. So we have to really state the truth there. Okay. Third important point is ensuring that core DPDP principles are met. For example, clear notice, valid consent, a lawful basis of processing personal data. Okay, is it consent? Is it other legitimate grounds? All of that. Also, you'll have to look at important data protection principles, which are true for most legislations across the globe, including GDPR, CCP, etc. Is purpose limitation. For what purpose did I tell the individual that the data would be used? Have I repurposed it for something else when I have been using it for in the AI context? Data minimization. All data laws would be talking about using minimum data. However, when you look at AI system, they would like to guzzle more in most of these cases, okay, in large language models, etc. And finally, most importantly, would be appropriate security safeguards. If you see the penalty, which is humongous under DPDP Act, 250 crore rupees or more, most of it, the first important bucket of 250 crore is tied to security of the data. So we have to ensure that whatever happens, whether it is happening at my premise, at under my control, or if I've given it to a processor, the breach has happened there, I would still be responsible, and the penalty can go up to 250 crore rupees. Right? So therefore, it is important. Next important aspect I would say is putting in place a very robust data processing agreement and the roles and responsibilities QA AI vendors, especially, I would say in cross-border data transfers, we have seen tremendous amount of issues in case there is a breach. In one of the instances, what happened, a client faced an issue and they came to us and said, we have about 16 jurisdictions data which has gotten compromised? Can we overnight find out that if there is a data breach of this sort because of AI misuse, related misuse, what is the repercussion? So we were trying to find it out, etc. And next morning comes the next instruction. Can you also find out if we have to pay ransom? What will be the exposure to all these jurisdictions? So if you are not pre-aware of the lay of the land, it could be quite difficult. Last point I would like to mention is establishing a simple, repeatable procedure to handle data principal rights. Individuals who are giving their data, whether it is your employees or customers or vendors, can come knocking at your door when the DPDP Act is fully enforced in May 2027. What data do you have about me? I want to get a summary of the data. I want to erase my data, rectify my data. It has been guzzled into AI system, which cannot really throw up any of that information. You could be in trouble. So we have to ensure that we have that procedure possible within the AI ecosystem that we are building, so that we are able to attend to such requirements. Or otherwise, we should think of avenues like aggregated anonymized data being used, or other exceptions and exemptions, just like your in the DPDP Act you have research as an exemption. All these avenues, can we utilize them in order to have our AI play? So that's in a nutshell. Samir, back to you.
Hold that thought on the agreements, because I've always wanted to talk a lot more about it, and I will come back to you. But uh, a very interesting point that you made is the entire implementation of the DPDP Act. And I think all of corporate India is right now indulging in gap analysis. What do they need to do to migrate systems and so on? Now, if they're going through that exercise, then Ishan, coming back to what you said in the beginning, that do people even know where is AI being operationalized in their systems? Wouldn't this get unearthed as a part of the automatic corollary of the gap analysis or the audit that you do for DPDP compliance? Is it really true that people don't know where all AI is being employed in their systems?
Absolutely, Samir. I think, and that's a great point, right? Organizations are already conducting this gap analysis, and it is a fact that in the last 2 years, there's been so much of AI deployment, and there is limited visibility on it. And this is true not just for sector agnostic issues, but also for companies which are technology first. While enterprise AI is fine, it's great, right? Companies have entered into contracts where custom AI is available to them for their workflows, but there's so many employees out there who are using consumer AI, and consumer AI is easily accessible. It's accessible at cheap rates, and at the end of the day, the aim is efficient workflow. So for employees, it is an incentive to use this. So I think there's a lot of shadow AI that is being used. Organizations and leadership is not aware of this shadow AI and where it is being used. And shadow AI is not just consumer AI, right? There's another aspect to it, and we tend to forget about it. That's existing technology and existing platforms, SaaS platforms that organizations are using may have AI embedded in it, and that is something very easy to miss. So I think it's very important, while this gap analysis is being done from a, say, a data privacy perspective, or for some other regulated entities from other regulations, right? That audit can also run parallel with an AI audit, where you do a full mapping exercise end to end of what AI is being used, whether it's enterprise AI, whether it's consumer AI, or if it's being inbuilt into some vendor technology that you're using from third parties. Now, as a starting point, great to do that AI mapping and then refresh that AI mapping from time to time. Make it into a dialogue with your employees, with different business units, to discover what are great AI tools to use and what are their risks or limitations, and what are the terms and conditions that come with it. So I think that's a great starting point and can be then built into a larger governance framework.
Understood. And see what amplifies this concern for me. Let's assume I am a thoughtful organization. I have gone down to the basics. In short, my employees are working as per their obligations, as per their responsibilities. But what do I do about my vendors? And particularly in Shubhrutin, this is where when we did a survey as a part of this webinar's registration, bulk of the questions we've received are on contracts, on vendor contracts. So I will maybe split this question into two parts. To begin with, what are the contractual risks that you see clients are now thinking about more often than not when it comes to, let's say, AI vendor agreements?
Right. Again, super question, I think, for today's webinar. There are many. Okay, now let me see. I'll try and call out the most critical ones. I would say the first one is very broad vendor rights to use customer data. Okay, including personal and also confidential data for training or other purposes. Okay, sometimes these are so vague and nebulous that anything can fit in there without sufficient limits or any anonymization guarantees. And many a times what happens, the seller knows a bit of what they are selling. The buyer probably knows even lesser. And therefore what's happening is people have been sold just anything without any promise on what happens to the underlying data, how it is getting utilized. Second would be weak or excluded indemnities for data breaches or important aspects like IP infringement or regulatory penalties which are arising from vendors' technology or AI output that is coming out, right? Third, I would say is strong disclaimers that outputs are as is and not fit for purpose, etc. Effectively pushing almost all the legal and compliance risk onto the customer, right? Next, I would say is the lack of transparency, obligations around model updates and training data sources, sub-processors, and the security practices that are there. And what happens, I just mentioned earlier, Sameer, that under, say, a DPDP Act, liability is that on the controller. Therefore, that if not passed on contractually, uh, the organization, the controller would be at risk. And at times, when you look at some of these AI players with whom you've contracted, could be fairly, kind of small. And if really a 250 crore rupee penalty comes, that organization will probably shut shop, but you would be fully responsible, liable to make that payment. I'm not even talking about the reputational harm. Next important point would be insufficient audit, testing, termination related rights for customers when AI performance or bias profile or risk profile changes materially. At times, Samir, I have seen that probably the coffee vending machine and the AI service provider or the tool provider has been onboarded with the same base template. It's so brutally rudimentary, right? So we need to kind of relook at these. And the last point is for regulated entities, which is, you know, Shumantru just mentioned that we are at a very, initial stages of lawmaking. But interestingly, what's happening, whilst the sector neutral laws are getting prepared, the sector regulators have not waited, just like your data legislation. The Reserve Bank of India, the securities regulator, SEBI, insurance regulator, IRDI, all have started talking about what should or should not be done in the context of AI, right? So we need to be aware of that, and there should not be any misalignment to what the sector regulator is saying and what I have agreed with an AI vendor. So I'll stop there. There are many more to talk about, but in the interest of time, I'll pause. Back to you, Sumit.
So just on sector specific, there's an audience question from the life sciences sector. We'll come to that a little later. But realistically, Supratim, I think you've articulated a whole host of risks arising from contracts. Now, what I would like to understand is, I'm a general counsel. Yes, there are risks. Is it a risk which I should just bite the bullet on because there's really nothing I can do about it? Do I separately go and get some kind of insurance on it? Or is it realistically possible for me to actually negotiate AI liability protection with my vendors? What's the likelihood of vendors being sympathetic and receptive to this kind of an ask?
Completely understand, and this is actually the practical difficulty I think that all GCs are today facing probably. So yes, but it is usually realistic only if GCs prioritize high risk use cases and probably key vendors instead of seeking perfect protection everywhere all around. Okay, so there's a bit of a mapping, and that's why I love the EU AI Act in some sense, that they have graded things fairly well. Okay, what is unacceptable risk, what is a high risk category, what is moderate, what is acceptable, and that's how probably that's the lens that we should apply. It's called the Brussels effect. Ultimately probably many jurisdictions will get inspired from this thought process, but internally also I think GC should get inspired by this thought process, that can I grade it basis the risk involved. We should push for specific indemnities for IP protection and say data protection violations that are attributable to the vendors' technology, training data, and security failures. We should definitely try and seek a clear share responsibility model that allocate obligations for the data quality, the human review that should happen, the permitted use cases, and the security controls. Also, I think we should negotiate a service level for accuracy where appropriate, as well as the uptime, incident response, and timely notification of material, model, and feature changes occur. So I'll give you a simple example. What has happened is, thanks to the chat GPTs of the world, the body of the agreement has been fairly sorted. What occurs is the issue occurs mostly in relation to the schedules that are there, where you should have written your uptime, incident response related SOPs. All of those should have been more clearly articulated. There, probably the business team, the tech team, and the legal team did not sit together and articulate things properly or granularly. And when there is a real issue, we observe that this is so loosely worded that it can be interpreted in any way, right? So I think there we should be a little careful. Even if vendors resist, broadly uncapped liability targeted as super caps or uncapped indemnities for, say, DPDP breaches or in IP infringement and data security incidents are often, I think, achievable for strategic and larger customers, and we have to sort of negotiate well. So that's about it. I think, Samir, in a nutshell, that's all that I would like to convey on this.
Understood. No, and again, it goes back to that same point of decision making, really. And a lot of what you said is in terms of the input I will receive from the vendors will be used by the institution or by the organization in their own decision making. But given there is a possibility, like you said, Supratim, of negotiating SLAs, of ensuring that the right levels of accuracy are specified by the contract. Shubhantru, just asking you, how real is this risk of AI-based bias or discrimination? I mean, is it really a problem, or is it just a question of what quality of AI you are using?
That's a very good question, and this is more from the technology side, but it has real world implications for the deployer as well. And I'll start off with this answer first. In terms of when we talk about bias, there can be two kinds. One is emanating from the use of what kind of training data was fed into that particular tool while developing that particular algorithm, right? That's number one. And the second kind of bias that tends to happen is more from a deployer side, based on the kind of prompts that you're using. And I'll explain both. Maybe I'll start off with the first part on this, is that particularly in India, where we've not made much progress in terms of development of algorithms in this country, or even in a lot of the areas in the world other than a few countries. Therefore, there is unfortunately, a skew towards the kind of data that is used while training algorithms. Now, where do you find the risk on such an issue? So, for instance, let's say in India, where there's a huge diverse socioeconomic background of internet users, for example. Obviously, there are various categories of people whose online presence or online behavior is very little. So in terms of what would be their preferences, or how to deal with or how to develop products aimed at such audiences, the AI solution may not work altogether, because their behavior was never taken into account by the person who was developing the algorithm. That's of course something that companies, GCs, cannot really do something about. But what they can do is, when I talk about the second part of it, in terms of what kind of prompts are you using, are you relying on a single standard set of prompts for any sort of problems that the organization faces? Who in the organization is, for instance, taking charge on labeling what kind of AI output was generated, what kind of input was given? When you're, especially, let's say, I'll give some examples, and obviously there's severity of different kinds. But let's say if someone is deploying a driver assist on Indian roads, perhaps an AI which was developed based on data in another country where drivers actually follow rules, or there are more standardized traffic segments, And if you try to use that in India, unfortunately, that is not going to work. When you look at the kind of road conditions, behavior of other users, etc. Interestingly, in the healthcare space, for instance, let's say you feed in a set of X-rays on an AI tool. What in another country, based on their X-rays, the AI might throw up a result of one disease, it may not in the Indian context, because let's say tuberculosis in India is fairly prevalent as opposed to other countries. So, from the deployer side, from the GC side, again, as I mentioned, that while you cannot do much in terms of understanding what the underlying data in the tool is, and particularly, again, I go back to that point that in India we're still really grappling with what kind of patchworker laws we're going to use. I go back to the European example. This year, there's been an amendment to the Product Liability Directive, for instance, where they are now talking about labeling and also producers being liable for any sort of use of AI. And this will cover not only the developer, but the deployer side as well. And you can, again, expect such regulations to come into effect in India. And at the end of the day, no regulator, no government will want AI to be used without there being some accountability, at least, even if there are no direct regulations on bias and ethical principles. Different countries have tried to really kind of hardwire what ethical principles should be there, what kind of bias reduction elements will be there. But it's kind of like robotics law, law of unintended consequences. What is bias in one country may not be in others. Again, if you think about it, in India, there's different kinds of castes, for instance, different socioeconomic backgrounds, and therefore you would actually want AI to figure out the differences. Because let's say if you're doing credit scoring, for instance, and you want to figure out, which person is suited for what kind of your financial product, that in India is unique. So it's not that bias in itself is bad. And the question is, from the GC's perspective, is that what as an organization are you really trying to do? What are your use cases? And take accountability for the results, rather than trying to really figure out, okay, which AI tool was used, was trained on which kind of data, because that kind of information is likely never really going to reach your doorstep. And even if it does, even if you're looking at the terms and conditions, it's very unlikely that you can completely absolve yourself of liability. Back to you, Samir.
Great. And again, it goes back to the same point, right? So we first need to identify these issues for our general counsel friends to be able to address them. Now, Ishan, back to you. And I know this is something you've been hounded with ever since the governance guidelines came out. If, let's say, a general counsel approaches you and says, well, give me the top few things, uh, what should I put in my governance framework? But more importantly, what is realistic? How do I come down from a utopia to something more pragmatic and implementable? What are the few things you recommend to them to include in a more realistic compliance framework?
Thanks for that, Samir. I think, Samir, it's very important for general counsels to first identify what kind of risk they're looking at in their day-to-day business also. Like, to give you an example, and this is from back in 2023 when AI use was still nascent, a very large tech company, their employees wanted to optimize certain code, and they did it using a consumer AI. Now, the entire code was copy-pasted on the consumer AI and eventually ended up getting leaked. So this is really a governance failure in that sense, where there was no control on the use of AI. Then we're all aware of, say, the Deloitte incident in Australia, where certain citations were generated by through hallucination by AI, and that really went down to the core of duty of care. Because you're working in a regulated sector, you're making representations to a government, right? So this is why there's real importance in having a very robust governance framework around use of AI in every organization. I think we're at the start of the year, and it's a great 2026 resolution for legal and compliance teams also to put in place that by the end of the year, they will achieve this framework structure. Now, if I were to look at it really from a robust framework perspective, it should be ideally multi-pronged. One is, of course, putting a AI policy in place. And unfortunately, because of the quick evolution of AI and its use cases, it's very hard to get into granularities at this stage, right? So it should be broad, brushed, principle-based approach, identifying risks and harms and then trying to address them. Doing this whole risk classification that Supratim was also mentioning. What could be low risk? What could be medium risk? What are your high risk instances? Like, for example, if you are using AI only for calendar management, summarizing meeting notes, perhaps that's a low risk scenario and can be more likely regulated within the organization. If it's, say, client communication or content creation that is going out as promotional material, perhaps that would be a medium risk case. If you're creating IP that is really core to your business, that becomes a high risk use case and must be more tightly controlled and governed. Then there needs to be a governance committee. I would think that should be your second prong on governance. Have an interdisciplinary governance committee in place. This is AI regulation cannot become the sole job of the legal and compliance team. You need to work in tandem with other disciplines within the organization. You need to have your IT team on board, your business unit and stakeholders on board, because these are the other faculties within the organization that will really help you assess the risk and mitigate it. So have a interdisciplinary governance committee in place, which looks at AI policy, AI use cases, certain risk scenarios are flagged to them from time to time. And this whole process should refresh within, say, I would think 3 to 6 months, because that's the pace at which AI and its use cases are developing. The third really important thing to me would be to have a standard operating procedure in place. And that should be across the board, from use of AI in day-to-day workflows, in terms of implementing of technology also, perhaps, for your tech teams to put in place monitoring mechanisms, what kind of volume is being used, what kind of data is being uploaded to AI, both from an enterprise AI perspective and more high-risk consumer AI perspective. What kind of data is allowed in each case to be uploaded? Where should human in loop come into picture? What kind of assessment is to be done of the AI work product? So putting in place those standard SOPs for users, and then a subset of that would be to put in a standard SOP for your vendors also. So when you're getting any technology or platform on board, see what is the AI that is underlying that technology, and what kind of data is it trained on. Is that licensed data? Is it unlicensed data? What is the level of accuracy that that platform guarantees? And then based on that, make a risk assessment on tying it back to your risk classification, right? As to where this AI can be put into use. Would it fall in the low risk, medium risk, high risk categories? So I think it needs to be a more holistic and robust framework, and it needs to be pursuant to a dialogue between different teams within the organization.
Understood. And what I really, one thing which I really enjoy is your use of the phrase consumer AI, because a lot of people talk about it as publicly available AI or otherwise. I love the difference on consumer AI. And maybe, Shumantro, that's a question, and maybe a little bit of for and against. If you had to debate this, if you were a GC, how would you clearly, there is merit in restricting the use of consumer AI or public generative AI tools. But should there be some limited use cases in which this should be allowed? How would you put your thinking hat on if you were a general counsel framing a policy?
And I think, to be realistic, people are using AI whether organizations have a policy or not. I think the time of really thinking that you're going to have an official policy and then people are going to use AI, I think that's really not going to work in practice, because people are going to use tools which help them in their work. So I think it's important to have that mindset that this is meant to be a tool which will aid different sorts of teams in their functions. I think, again, the thing, as Ishan was mentioning, the key here is, what are you using AI for? Let's take the lowest risk situations, for instance. You have an internal presentation, maybe you're trying to do some research, or you want to put together a short deck, based on material that you've gathered. That's a fairly low risk sort of a use case to use. I think where it starts going into the gray And especially from a GC's perspective, I'll give an example from the legal team's perspective, let's say. There have been actually submissions to courts where case citations have been completely hallucinated. Now, that is obviously a very high risk situation. Whenever there are submissions being made to third parties, courts, regulators, definitely there has to be a proper labeling and proper ways with which individuals can identify who was responsible for checking or who was responsible for a particular content going in. We've already talked about the Deloitte example today. That is exactly the kind of nightmare that can happen, especially when you're looking at your products and offerings to your customers. That is definitely a use case which has to be monitored more. In terms of again organizational responsibility, the problem is that one person cannot really be running around and checking okay, are 1000 employees in the organization following these SOPs or the policy, right? Therefore, in terms of each kinds of teams, it is better to have a sort of risk matrix, right? Business teams are obviously the most important because they are likely to use AI in your customer facing operations. So for them, it's very important to have very clear SOPs as to where and what they're using. Again, it depends on the kind of sector that you're in. If you're in a financial sector, for instance, if you're in healthcare sector, for instance, definitely the barometer goes up in terms of what kind of human oversight is required. Whereas if you're looking to some internal tweaks in your organization in terms of productivity, etc., those are things where cross teams can collaborate to figure out, okay, who's going to take liability for this. At the end of the day, again, you have to remember that whatever liability regimes that apply under law to you will continue to apply. On a bad day, if a regulator is picking something up, even if it's a gray area, even if there are no clear regulations or guidelines, sometimes if the regulator asks as to who was responsible, someone in the organization will have to stand up and own that responsibility regardless of which team was using and deploying AI. So therefore, I wouldn't say that I mean it is a little bit of a daunting task sometimes, because one person cannot take responsibility. It is not the GC alone, but there will have to be other vertical heads. At times, even at a board level, there will have to be some sort of messaging downwards as to what kind of business risks that can emanate from use of AI. So, it's not. This has to be a decentralized approach. If you're going to have one GC really go into each and every team and monitor that, okay, what was the output and where did you use, that is what the GC is going to be doing the entire day, and every other regulation that the company has to follow will simply go by the wayside. So again, I'm a technologist. Technology, whenever once it's really there, it's here to stay. This is not going to go anywhere. But it's important to have honest conversations as to where and how AI is supposed to be used by the organization, and having sort of decentralized approaches to governing how teams use them. Back to you, Samir.
Yeah, no, and I think you hit the nail on the head. Accountability tends to be a little bit of an issue. And while I'd like to believe that it's not the general counsel's job to go and find accountability each time, more often than not, internally, let's say if two teams are at war, they will eventually go back to the management, and the management will look to their resident legal to come up with the answer on who's really responsible. Now, interestingly, so when it comes to framing these governance policies, I'm sure accountability as to whose hat sits on whose head, I think we need to come up with that answer. So Ishan, to your mind, uh, when it comes to looking at accountability, what are the kind of rules you can use within organizations to fairly and transparently uh, dispel accountability across the board?
So I think it's very easy to, get wrapped up in the whole AI conversation about decision making and automation, Samir. But it's very important to have that clear principle in place that AI does not own an outcome. It is individuals who own that outcome. and therefore responsibility and allocation sits with individuals at the end of the day. And I think Sumantra very beautifully put it across that who is that individual could be a pain point, but that has to be identified at the end of the day, right? And that's where this whole allocation piece comes in. To my mind, I think we should look at it from a top-down perspective. So first, it's your board who will put in place your AI policy. And we've spoken about the AI policy. It needs to be principle-based. You need to identify risks and harms in specific scenarios. And then the next step comes for the management to start implementing that policy, right? A policy needs to flow through to different divisions within the organization, how they are using AI and what is uh, how it is being implemented. I think then it needs to follow a layered approach. So, for example, a very low risk item, like say summarization or calendar management, becomes that individual's responsibility. Whoever is the end user of the AI needs to make sure that they have cross checked the output. Now, if it were to be, say, a more business driven decision making, it becomes the business unit's responsibility, that what is the final output if it's a client product, whether that client product has been checked or not checked. So that human in the loop becomes very important, and the business unit owner or the head of that business unit needs to make sure that whatever goes out is going out as if AI was not used. Right? AI is only a tool at the end of the day. We must look at every work product as if AI has not been used. Then comes the legal team, and I think while legal team cannot own the business decision itself, their role is highly critical because they are the ones who will own the standards of how things are being complied with and rules that are being set in place. So those SOPs need to come from the business team, from the legal team rather. And also another step that they can take in place is to create awareness around AI risk and liability, because that coming from the legal team has a very large impact on the organization as such. And this awareness process needs to be really inculcated in organizations because this is the future, right? AI use in workplace and automation is the future, and we need to work as if to set in place those SOPs. The fourth limb, I would think, is working in tandem with the technology teams. And technology teams need to take on ownership again on compliance. So when I say, so for example, we were talking about, copy pasting of codes into a consumer AI earlier. Now, in that case, whose failure was it? It's important to understand, while yes, the business unit needs to be aware of what information is being put in place, the second leg of compliance can always be implemented from the tech team's perspective. Put in place monitoring tools, put in place blockers so that there's no data loss. Or, there are flags that are being raised that is this data appropriate to be used on a consumer AI? Is this data confidential, proprietary? Map the volume of data that is being used on AI. So all of that can be done in tandem between the legal teams and the technology team. And then finally, uh, for some high risk elements or for some use cases which are not ordinary course of business, those need to always be flagged to the board or to the management. So put in place that policy so that where there is a new use case being put in, coming up, that gets flagged to the right person, and only then those high risk elements can be moved forward. So yes, while a human in the loop is not an easy answer to find, the framework in governance needs to put in place different allocations, and that will depend on different portions of the liability that you're trying to ascertain.
Understood. Wonderful. So I'm just conscious of time, and from what we had originally thought of, we have two questions now, one for Shukritin, one for Shumantra. And then we'll go to audience questions. And the chat box has been buzzing. So gentlemen, gird your loins, as they say. And what I'll really ask you is, Shupratim, you've heard everything thus far. And I would say clearly you're one of our most prominent experts when it comes to tech laws, when it comes to the ever-evolving landscape that you've seen grow. People know the risks, right? But then what are the mistakes? What are the most common mistakes you see people still making in the context of artificial intelligence? And after you answer that, Shupratim, Shumantro, please sum it all up. Tell us, if you're a general counsel, what do you want to think about? And what would the board be asking you in terms of your preparedness, your readiness, and what have you?
Thank you, Samir. I think there are many, many such mistakes to talk about, and we keep unraveling these every day. I think the first one would be treating AI as an IT project. Okay. Second one I would say is that just simply copy pasting some foreign policy and assuming that this is good for the Indian scenario, good for the particular organization, then the AI play that they have, right? Third, I would say that there is no law, so need not worry about anything. But fortunately or unfortunately, there are a number of laws, either directly or indirectly, already impacting AI use cases, plays. Interestingly, a lot of matters have already reached the court. We are assisting on some of the landmark litigations in this space. Next, I would say treating AI pilots as just experiments, okay, that do not need any legal or privacy or security review, even when they are using actual real data and are affecting real customers and employees, right? Next is allowing broad data sharing. We already spoke about it with our vendors without really understanding how that data is getting used, stored, or combined, or even used for training, including the cross-border implication part of it, which we spoke about. Next is relying blindly on the AI in output without human validation. We have seen, chatbots of organization bad-mouthing the organization itself with certain prompts, right? Next, I would say is failing to maintain an AI inventory, which I think has been spoken about enough during the course of this session. Another would be not updating the codes of conduct, information security policy, or AI employee training policy, all of this with the Gen AI and automated decision making aspects explicitly. Okay, we think that we could create, say, maybe one hard coded policy and keep it somewhere, and that will take care of all aspects pertaining to AI in all our policies. That may not really work well. So we have to think through how do we engrave that into each of these relevant policies. And finally, I would say mostly from a GC or a CTO perspective, not nominating a single owner for to coordinate the AI related legal privacy and governance issues. These are, I think, Samir, as a snapshot, the most common mistakes that we are observing in the market today.
And Shomantro, mindful of all of this, what is it that you as a general counsel would expect the board to want to hear from time to time by way of updates and summaries and so on?
I think the very first question from the board is going to come is, are we using AI and are we doing things that our competitors are doing? If you're not doing it, why aren't we doing it? What the problem is? And I think that's where the problem statement starts. It's very unlikely that someone's going to say, okay, it's best not to use AI, so let's not talk about it any further. And the first question is really going to be, what in the industry is happening and where are we on it? Are we a front runner? Are we imitating others? What is the value add that is happening from use of AI in the organization? And stemming from that, the second one that is going to be is what kind of business, first of all, business related risks, what do they foresee? Because that's the first question is going to spring to their mind, because if you ultimately all of this is for developing product solutions for people in the market, so business and reputational risk is definitely going to be first in their mind. And second level of risk is of course going to be on what kind of regulations are there today and what's also in the pipeline. Different industries have different kinds of regulators who have different sort of approach. Some are more proactive than others. We've already had that discussion, of course, when Shibata was talking about financial sector regulators, for instance. So because again, all the effort that is going to go in from a strategy perspective into the company business strategy, and if legal risk happens to be an impediment, that is something the board will of course want to hear about. So again, it's not just about the law today, but about being updated with the law going forward, because developments keep happening. It's a dynamic space. And of course, stemming from your business risk, your legal risk, is a governance standpoint that ultimately a board would want to hear what kind of solutions are there, what kind of line reporting is there. It's not about technical details or what can't happen, is not really what is going to add value as a GC. To find out solutions from a governance standpoint, considering all the regulations that are there as to who takes liability where, and keeping the organization also nimble in terms of having people who can also step in. It's not just the line heads who will take responsibility, but also other functional personnel who will help these line heads have a sort of dotted line reporting that there were people to sign off on outputs of AI which are being used, whether it be products or internally. So these are the sort of primary questions that I would expect boards to ask of their GCs. Back to you, Sunny.
Great. I think with that, at least the questions we have thought of putting together for the panel discussion are over. With that, maybe we'll just switch to the audience Q&A. And why don't I start with Ishan first? So, Ishan, just basis what you briefly mentioned on intellectual property, there's a question on how do you see intellectual property issues playing out for artificial intelligence generated outputs in India?
So Samir, I mean, great question, and I think everybody's thinking about this. Lawmakers are grappling, regulators are thinking about it, and how it will play out in the future. I think there are three things really to think about. One is originality of the work and whether any AI generated output even qualifies for IP protection. The underlying principle of real IP protection was to incentivize creators. Now, if there's no individual to be incentivized, would it still amount to something that can be protected under the IP regime? Uh, the second bit is, of course, whether AI is being used as a tool and there's still enough creativity or human input involved for it to qualify, and what is that threshold going to be? So that is something that we'll see in the coming days, perhaps, because this is to something that is in the legislator's mind and the regulator's mind while determining IP eligibility and qualifying for originality, really. The second real important aspect on IP is what is the data that is being used to train that AI, and whether that impacts the output at all, right? At least we are clear in this that the data or the works that are trainable have IP protection. Now, question is whether it is fair dealing or whether a license is required. And of course, our courts are dealing with it in some landmark, soon to be landmark orders, right? On whether there is a license required or not. And from an organization's perspective, at least, we need to make sure that aspect of IP you get insulated from. Make sure that your terms and conditions are very clear, that whatever data training is being done in a legitimate manner, and that you are insulated from liability on that front. The third aspect, and this may be more important for sectors where there's a lot of information or content that is going out. It could be, say, the edtech sector, where there's a lot of educational content being posted on their websites. It could be the entertainment sector where content is being posted. Now, how do you protect from that content becoming training data? That is also something that legal teams and GCs should be mindful of, and that's a very important aspect of IP right now. Two things that come to my mind really, Samir, is one, to put in terms and conditions that say that, okay, this data cannot be used for training. And two, again, work with your tech teams to put in technology such that data cannot be crawled or scraped from those websites. So all in all, I think it's a holistic picture on IP that needs to be looked at from an AI perspective.
Understood. We have a very interesting question, and this goes to the root of general counsels as individuals and not just as people who are responsible for a function. And this is a little bit of a scary question, so please feel free to speak unabashedly. But Sumantro, maybe you want to talk about, is there personal exposure for general counsels in the event of any kind of failure by artificial intelligence?
Right, Sami. So, again, I think the question on that is the simple answer in terms of legal implications and personal exposure is whatever there is under law today, wherever it provides for penalties for, let's say, key managerial personnel or directors, that does not go away. Use of AI does not take away any sort of personal liability that are there under different laws and regulations which are applicable to that particular company. And of course, this can be layered. Of course, there could be sectoral regulators as well, so they will also have a mind of their own. So, I think two important things, if I were to bring up here, is number one, thinking that somehow use of AI takes away from personal liability or corporate liability under law. That is a very incorrect approach to take. And the second is, from the GC's perspective, is to really not have a mindset to say if anything goes wrong. I never knew that people were using AI because we don't have a policy around it. So the employer should have never used it, because this approach of thinking that people are not using AI just because we don't have a policy is likely to backfire. Because again, if you look at the kind of offerings that are there on the market, the easy accessibility that is there, particularly in India, it's just inconceivable that people are not using this for their work. So certainly that is one thing that's a key takeaway from this question, is that you have to accept the fact that people are using AI. And therefore the question is that, are you being proactive enough? Did you have a policy, for instance? And going beyond just policies, was the board always kept informed of activities that you became aware of? And let's say you had discussions with cross-functional teams, that there are certain use cases, that there are certain activities ongoing, keeping the board in confidence and not just waiting for them to ask questions. That is another great way of spreading that. I wouldn't say spreading risk. I would say allocating responsibility across the organization. A key element under different laws when it comes to personal liability is that were you negligent, or were you also in connivance of that particular contravention? So just like there are other ways, in terms of policies, but also your own individual actions of keeping stakeholders informed, being proactive on the issue that people are using or maybe considering use it for different use cases. All of these can go a tremendous way in sort of dealing with this issue. It's important not to panic, but be proactive and be aware of where the organization is using AI and where it intends to do so. Back to you, Sunil.
Thank you, Shumantra. And we are over time. We've shot over, but I want Supratim to help us end this. So Supratim, we all have to pick our battles. Let's say you are a general counsel. You have 6 months, but you can only pick three things that you can fix or preempt or address in this entire conundrum. What are those three things to your choice?
Yeah, thanks, Samir. A good question to end. I think I would keep it short. Firstly, we talked about mapping of the AI use cases. That's super important. Second, I would say putting in place a baseline AI policy. Okay, at least. Third would be a review and upgrade of the contracts, maybe starting on a high risk basis, the most critical ones that you have, who are your entity. Okay, these are the topmost ones. Of course, there are many others, but I would like to stop there, considering the constraint of time.
Perfect. Thanks, everybody. And apologies. I can see that there are some very interesting questions on the DPDP Act, on contracts, on I can see something specific to the life sciences sector. So, ladies and gentlemen, we have your contact details. We will, of course, be responding to everything separately offline, and we will also circulate summary notes. If there are other things you want to touch base with us on, please feel free. We're always available. But again, before closing today's event, if I have to give some of my three key takeaways, because I'd love to talk about it, I think the most important fact is that it's very clear governance seems to have fallen behind. The statistic Ishan gave, 80% of the workforce is already adapting AI. If it's meant to help them do more for less, why would they not bring in that efficiency for themselves personally and for the organization more institutionally? But the important aspect is that the governance has to be a very good mix of internal and external risks being addressed. And not only do you have to contain and address such risks, you also have to clarify accountability where the risks eventually do come to roost at home. So To do all of this, you need to drown the noise, because there is indeed an incredible amount of noise around what AI can or cannot do, should or should not do. And it's important to focus on the actual issues. And this is where you need people who are able to cut to the chase, who have the necessary qualification and the necessary foresight to help you develop these policies. And once again, thank you very much to everyone who participated in that poll. And I want to thank all of our panel members for sharing their expertise and their experience with us today. This is a very fast evolving, ever changing landscape, and they bring such a wealth of experience to talk about such a esoteric subject so lucidly. And thank you very much to our audience. You were very attentive, very engaging. Your questions kept us busy. And we do hope that you found the webinar to be a good, interesting, and worthwhile investment of your time. You will separately receive a request for your feedback. It won't take you more than a minute. It's a very short form. And in case if you have interest in further matters on in-house training or any other matters in relation to artificial intelligence, technology laws, data privacy, please do not hesitate to reach out to us. Our contacts information is on the slide in front of you. And with that, thank you for your attendance today, and we look forward to being with you again in future webinars in the in-house council forum. Thank you very much, ladies and gentlemen.
Thank you.